Hello friends, welcome to the second talk on the theme of the governor, power and functions. In the earlier talk, we talked about appointment and related issues. Today we will discuss about the executive powers of the governor. The union and state governments in India have close resemblances in terms of their organization, institutions, and the principles and patterns of governance related mechanisms. It is more correct to state that the central government is an example to be followed by the state. The governor of the state is like his counterpart, that is the president, in the central government. The office of the governor is analogous to the president in terms of executive, legislative, and judicial power, but not in the case of military, diplomatic, and emergency power. The office is only a constitutional one, or the governor is a nominal head of the state who acts on the advice of the Council of Ministers with Chief Minister as the head of the Council of Ministers. So, as I stated in the beginning, that in this talk we will discuss only about the executive powers. The Constitution in its article 154 vested all executive powers of the state in the office of the governor, which are exercised by him either directly or officers subordinate to him. The Constitution has mandated that while exercising powers, the governor has to act in accordance with the Constitution or in accordance with the aid and advice of the Council of Ministers of the concerned state as per the provision of the Constitution. The executive powers of the states vests in the office of the governor, and all executive actions, orders, and other instruments of the state governments are expressed in the name of the governor, and rules are framed by him for the more convenient transactions of the business of the state government. This kind of provision has been made there in Article 166. So, let us discuss one by one the executive powers of the governor. The first one is appointment of chief minister and other minister. This is the most important also. The governor is empowered by Article 164 of the Constitution to appoint chief minister and other minister of the council or other members of the Council of Ministers on the advice of the chief minister, subject to the provision made there in the Constitution 91st Amendment Act 2003. In this regard, the governor is responsible to ask the chief minister to prove the majority in the absence of clear majority of the chief minister's political party or parties having pre-poll alliance within a stipulated time period. The governor's course of action in such a situation has been different depending upon the factors like political affiliations of the governor, political party in power at the center, and the political party likely to claiming to be invited to form the government at the state level, political party of the chief minister appointed by the governor in the state. The governor course of action in such a situation has been different depending upon the factors like political affiliations of the governor, political party in power at the union government level, political party of the chief minister appointed by the governor in the state, strength of the political party of the chief minister, and the supporting parties, etc. The principle followed by the governors are either to invite the leader of a single largest party to form the government, or based on their assessment, who can provide stable government at the state level. The governor also helped the chief minister in defeating the vote of confidence against them, and also engendering defection and spurting vote of no confidence against them, or asking those to resign even without asking to prove the majority in the state assembly. The governor is also constitutionally empowered to appoint and dismiss minister or the members of the state council of ministers. However, it is on the recommendations of the chief minister, having confidence of the state assembly. If the chief minister does not have the confidence of the state legislature, in that circumstances, governor is not bound to act as per the advice or as per the recommendation made by the chief minister. The governor also allocates the business to the minister based on the advice tendered by the chief minister of the state. The minister hold office during the pleasure of the governor, although the pleasure is restricted to by the confidence of the legislative assembly and the faith of the chief minister in the minister or the ministers of the state. The governor administers the oath of office and secrecy to the chief minister and ministers as provided in the third schedule of the constitution. There are certain other appointments in the state which are made by the governor. The governor in actual has the power to appoint Advocate General of the state, and the person to be appointed must be a person who is qualified to be appointed as the judge of the High Court. Besides this, the chairpersons and the members of the State Public Service Commission, as per provision made there in Article 316, and the authority to constitute a State Finance Commission, as per the provision made there in Article 243I, is entrusted to the office of the governor. The governor has the right to keep himself informed about all decisions taken by the Council of Ministers and relating to the administration of the affairs of the state and proposal for legislation. The Chief Minister of the state has the duty to communicate such decisions and proposal to him, or he himself call for such information from the government, and the Chief Minister is constitutionally obliged to furnish such information. Sometimes an executive decision on a matter is taken by a minister, but that has not been considered by the Council of Ministers or the Cabinet. The governor is entitled to obtain such information also, if it is required by him. Number 3, that is the power relating to the administration of scheduled area. The Constitution in its Part 10, Article 244, provides for the administration of scheduled areas and tribal areas, 5th schedule and the 6th schedule. According to this article, the power is vested in the office of the governor, but the prior consultation of the Tribal Advisory Council is mandatory in this regard. In other words, the governor is empowered to take the decision, but in the states which are having the tribal population, it is mandatory for that state to constitute a tribal advisory council, and the governor can take the decision. The governor can take the decision after consulting the tribal advisory council of the concerned state. Normally, the executive powers of the state are coextensive with the legislative powers of the state legislature. But there may be a situation when a situation or case is not covered under any law passed by the state legislature. In that circumstance, the governor can exercise his executive powers by administrative rules, orders, circulars and instructions, so long as the legislature does not make any law on the subject. There may also be a situation where the governor has the discretion to decide. Then it is expected that the incumbent in this constitutional office will discharge his responsibility in conformity to the spirit of the Constitution. Such situations sometimes lead to the central government interventions and arbitrary decisions, and that is why the governor is called as an agent of the central government. The possibility of such eventualities has resulted in wholesome removal of governors appointed by earlier government when there is a change in the power possessed by the political party at the central level. For example, in 2014 parliamentary election, when there was a change in the rule of the political party at the union government level, there was a mass removal or resignation of the governor of the states. It has not happened for the first time, rather there have been many such instances in the past also. The governor is a constitutional head and exercises power with the aid and advice of the Council of Ministers. However, the governor becomes de facto executive of the state during the proclamation of emergency under Article 352. Thus, in this talk we discussed about the important executive power of the governor of the state, and we found that in the absence of the absolute majority or clear majority of a political party, or in a situation when there is a different political party in power at the union government level and in the state government level, then the intervention of the governor has become more acute. Otherwise, it may remain a very cooperative one. But whatever it is very much clear that governor is a nominal head and a constitutional head, as well as he is the representative of the central government at the state government level. So, by this discussion, I hope you have been able to understand about the executive powers of the governor of a state. We will take up the legislative powers and other powers of the governor in the next talk. But till then, I wish you a happy learning. We'll be together again. Thank you very much.